Good morning, everyone. Thank you for attending. We want to get everybody an update on House Bill 0271. We've got Wally Irvin with us. He is a shareholder at Lewis Thomason out of the Nashville office. He is a huge advocate for the construction industry. Additionally, Mr. Irvin represents construction industry clients in administrative matters before the Tennessee Board of Licensing Contractors. He's and Tennessee Board of Architectural and Engineering Examiners. So again, he is a huge advocate for our industry. We appreciate all he's done. He has been working on this bill, I personally know, for at least a year and a half or so. And so we would like for him to just tell us where we are and what's going on with this bill. Wally, you have the floor.
I appreciate it. First, before I get started, Leslie had mentioned she might have a few announcements. Is that the case, or do you need me to go ahead and get started?
Well, we'll go ahead and get started, and if I may make some after your presentation. So.
All right.
Yeah. Well, one more thing, Wally's got to be off by 10:55. If you have any questions, please send them in the messenger. We'll try to get them answered. If we don't, maybe we can work on it via email later on. So, Wally, your deal.
Absolutely. Well, I appreciate the opportunity to speak with you all today regarding all the legislative changes that have happened here recently, but have been a work in progress, to say the least. But we'll talk a little bit initially about how we got here, why we got here, and then really where we are and how we can move forward with a lot of the changes that have been made. So again, my name is Wally Irvin. I'm a lawyer here in Nashville with Lewis Thomason. We've got offices in Knoxville, Nashville, and Memphis. I have been in the construction industry in some form really my entire life. I was in construction as my jobs in high school and college. I went to school to be in civil engineering, graduated with a civil engineering degree, and said that's fun, but I'm looking for something to be a part of the construction industry, but from a different perspective. And luckily had the opportunity to go to law school and then be able to practice construction law, representing contractors, subcontractors, architects, engineers for the past 15 years. So this is, as a lawyer, the construction statutes are something I deal with all the time. Pretty exclusively, because I don't dabble in construction law. It's all I do. Where we are now. So we're talking about construction statutes today, and when you say construction law, a lot of people may or may not know what you're referring to. So as you can see, the construction statutes, there's 4 principal construction statutes here in the state of Tennessee. The first are the mechanic lien laws, which I'm sure many of you are familiar with. This is what provides security to contractors and designers on construction projects for any of the labor, services, or materials that they provide. In the event you're not paid, you can actually record a lien against the property and be able to sell that, with the property being security for all of your efforts in the event you're ultimately not paid. The second is the Truth in Construction Act, which is really a secondary act to the mechanics lien laws. It's primarily a consumer protection act, focused mainly on the residential construction industry. It provides some initial pre-lien notices or pre-project notices relating to liens, requiring contractors to provide owners notice of a contractor's right to assert a lien against their property if they're not paid. It provides notice that the remote contractors in some instances will be able to record liens against the property, and then also has a couple of forms that are required to be filled out, both pre and post project, some lien waivers, and then also has a choice of law provision. And I say a choice of law, there's really no choice. It says Tennessee's law is going to govern. Importantly, with the Truth in Construction Act, it actually has some criminal penalties for noncompliance. And the whole idea is that this statute came around due to, you can make up an example, but what is frequently used is the little old lady who suffers some hail damage to her roof after a hailstorm. Fly-by-night contractor comes in, sells her on the idea that she's going to get a new roof, subcontracts it to a roofing company. They do the work. They don't get paid. The gentleman that she initially signed the contract with is long gone by that point, and the contractor records a lien against her house. And so in those instances, it's geared to try and provide some protection to the owner so that they're aware of somebody who is not familiar with the construction industry, that they're aware of their rights and some of the remedies that would be available to contractors if they're not paid. So it's more about communication than anything else. But if a contractor does not comply with that, there can be some criminal penalties. It's deemed a misdemeanor, which can result in jail time and some fines, depending on how bad it is. Those could be substantial. It can be upgraded. Then we've got the Prompt Pay Act of 1991, which is really the focus of a lot of the amendments that we're going to be talking about later. This is a statute that provides remedies and obligations for both parties or all parties on a construction project. The construction defect statute, which is really not utilized a whole lot in Tennessee and applies only to commercial construction, is really a notice and opportunity to cure statute. In the event there are any defects on a construction project or alleged defects, it provides a framework for which an owner can provide notice to the general contractor. The general contractor can pass those allegations down to the appropriate subcontractor and try and resolve any dispute that is arising out of those. So just talking a little bit, kind of a little primer to give you a background on where we were. This is in terms of the mechanics lien laws. As we talked about a second ago, the mechanics lien laws set forth who's entitled to a lien: prime contractors and remote contractors. For those of you who have been in business for 15, 20 years, you'll remember back in 2007 and before 2007, liens were really granted upon who you were, whether you were a general contractor, a subcontractor, a supplier, an architect, an engineer, a surveyor, and there were different time periods that applied to each one. Back in 2007, that was changed to simplify it a little bit and try and make the process a little easier, and so that every time you wanted to record a lien, you didn't necessarily have to go talk to a lawyer. They tried to make it a little easier for contractors to be able to do some of the initial work themselves. So they tried to shorten that or simplify it into having just prime contractors who have a contract with the owner and remote contractors who have a contract with anybody other than the owner. If you are a remote contractor, there's some notice requirements. It's generally the 90-day rule. If you're a remote contractor, everything is 90 days from something. Notices of non-payment have to be sent within 90 days of each month where you provide labor and services but are not paid. You have to provide a notice of lien within 90 days of completion of the project. If you are going to try and enforce that lien, you have to record a lien enforcement action within 90 days of service of the recorded notice of lien. Contrast that with prime contractors, who all they have to do is file a lien enforcement lawsuit within 1 year of completion. And as we talked about, the Truth in Construction Act, we're not going to spend a ton of time on, again, because it's primarily geared towards residential contractors, but it provides pre-construction notices, waivers of lien, and the choice of law provision in addition to the criminal penalties. Under it says current, it's really former Prompt Pay Act. It's important to note that the Prompt Pay Act only applies to written contracts. Oral contracts will not fall under the purview of the Prompt Pay Act. You actually have to have a written contract. It can be as simple as a purchase order, or as complicated as something you'd see on the Volkswagen plant, very thick. In terms of payment terms, the contractual term is going to govern whether it be 30 days, 60 days, 90 days, whether it have a pay when paid or pay if paid, that will control. In the absence of payment terms, like if you've got a very simple purchase order, we're going to do the work, you pay us, it defaults to 30 days after receipt, or a net 30. There's many provisions dealing with retainage. Historically, before 2010, 2012 or so, retainage used to be 10%. That more recently was reduced to 5%, which I hope is not a surprise to anybody, but something to take note of, because I still see it in contracts being 10%, particularly with some out-of-state contractors, so be aware of that. But it requires that retainage be placed in a separate interest-bearing escrow account with a third party. So, the owner, if they're a sophisticated entity, if they've got their own accounts, or if they're just holding back money, if it's cash, which is becoming more common, at least here in Nashville, It's money that has to be separated. It can't be left in the construction account. It actually has to be drawn out and placed into a separate account. That continues to accrue throughout the project, but it has to be paid within 90 days of substantial completion. Historically, retainage was thought of as a holdback in case there's defective work, in case a contractor wasn't willing to do punchless work, if there were any errors or omissions. That was money that the owner would go ahead and by contract say, well, we're going to take that money and we're going to just apply it to all of these defects. And you didn't, as a contractor, didn't really have a right to object too much to that. And there was very little in the way of relief if you disagreed with any of the actions of the owner, other than going to court and going through that process for potentially arbitration. A number of years ago, retainage changed dramatically to where it was really more of a completion guarantee, or something to guarantee the performance of a contractor throughout the project. The state of Tennessee put a deadline that retainage had to be paid within 90 days of substantial completion, no questions asked. So even if there was a dispute, it became an issue where the owner had to be proactive and had to file a lawsuit themselves, as opposed to waiting on a contractor to file whether it be a lien enforcement suit or a general contract, breach of contract case. Now all owners have to pay retainage within 90 days of substantial completion. That can be anything from when the architect issues a certificate of substantial completion to a use and occupancy permit, or when the property could have been used, not is used, but could have been used for its intended purpose. Really the only requirement on contractors to be able to take advantage of some of the provisions of the Prompt Pay Act is that they provide a 10-day notice to the owner, or if you're a remote contractor, a 10-day notice to the general contractor of your intent to seek relief under the Prompt Pay Act. Now, excuse me, as we'll talk about, in terms of applicability, one of the big things is that the Prompt Pay Act historically did not apply to lenders. It didn't apply to banks. It didn't apply to savings and loans, credit unions. If a project was financed by a surety or an insurance company, it did not apply. Just for historical context, when the Prompt Pay Act, this is the Prompt Pay Act of 1991, when it was initially passed, it did not contain any exemption. But there was some backroom dealings to try and work a deal right before it was signed, where it had to be repassed with that exception as part of the bill. And so if the question ever arises, well, how did that ever happen to begin with? It was something at the initial passage that was never really talked about between the parties that were coming up with this legislation. It was more of an afterthought. And due to, when times are good, there's, everybody's happy, there's no issues. It's when times are bad that you have problems. And so when this has been approached in the past that, hey, the Prompt Pay Act should apply to lenders, you get a lot of pushback from lenders, even on their own projects. I've had instances, particularly in West Tennessee, where a bank will be building their own branch. They don't make timely payments. They don't hold retainage properly, and there's really nothing you can do. You have a right, but no remedy under those circumstances. And finally, the construction defect statute, again, this is rarely used. In talking to some lawyers across the state, I would say it's maybe less than 10 times in the last 10 years. It's very infrequent that people actually use it. It's a very detailed statute. It is very well written, but practically on a construction project, it can be very difficult to actually utilize. The other aspect of that is most times contracts have their own notice and opportunity to cure provisions. So that would be the default under most circumstances, and it only applies to owner defects or owner claim defects. So if there's a defect that's alleged by the general contractor, this statute has no application. It's only when the owner makes a claim of some sort of defect on a construction project that it ever even comes into play. So it says internally inconsistent, and we'll talk about that here in a second. One of the issues historically, whenever any legislation is changed, particularly any of these construction statutes, is that somebody normally comes with a particular problem that addresses one particular section of the statute. Throughout the past 20 years, there have been many, many changes to all of these statutes. But when people are looking at them, it's strictly in isolation. So one of the issues that has arisen over the years is that you have a lot of unintended consequences with some of these changes. Even when you had wholesale changes to the mechanics lien laws back in 2007, where we changed the terminology, those changes did not get carried through to a lot of these other statutes, or at least not in total. So you have situations where you have different terms relating to the same person, creates ambiguity and some real enforcement problems when you have to go to court and try and convince the judge of what these statutes actually mean. Most construction lawyers have an understanding of what it should be, but every time I quote the law according to Wally, I get some funny looks from some judges who think they know better and generally try and impose their own position on what the law should be, as you would expect. So some background on this particular bill, House Bill 271, Senate Bill 324. This was an initiative of the American Subcontractors Association back in 2019. Tennessee works on a 2-year legislative cycle, and so this was initially pushed at the beginning of one of those 2-year cycles. This particular bill sought a number of changes from were within the construction statutes, some of which had some merit, others that were heavily opposed by members of the industry and the legal community. Some of those we'll talk about just briefly. Introduced the term subcontractor and work, or the terms subcontractor and work completed into the lien laws. As you can imagine, this caused a little bit of an issue with me personally, just because we got rid of the term subcontractor back in 2007. The term subcontractor is not used in the mechanics lien laws, nor is the term work completed. And so the question became, why are we inserting definitions that don't apply? Doesn't make a whole lot of sense. The second was that it extended deadlines for the remote contractors to serve notices of non-payment and record and serve liens to 120 days from 90 days. This is one that can make sense under a lot of circumstances. A lot of subcontractors, even though their contracts may say we're going to get paid in 30 days, a lot of times they're looking at 45, 60 days, maybe even longer. And so by the time, under a 90-day requirement, by the time a remote contractor actually recognizes that they need to take some action, they have very little room for error, very small margin there in terms of going ahead, taking a risk of sending a notice of non-payment, hurting a relationship that they may have with a general contractor, having to provide notice to an owner. That's one of those things that can cause some heartburn on a project, and so the idea was extend that to 120 days. Now there's extending the deadlines for remote contractors to file lien enforcement complaints, or a complaint to enforce their lien, for up to 1 year, which is what a general contractor has. Although that's a great benefit to a remote contractor, that can cause some problems for both the general contractor and the owner, who are providing lien waivers to the owner and to the lender to make sure that everything is in place. It can cause some problems when an owner tries to go and convert from construction financing to permanent financing. There were a number of people that were opposed to that. One was reducing the time period for the payment of retainage from 90 days to 30 days. Even right now, I've got a couple of projects where we can't convince the owner to release retainage, even though it's been 90 days, let alone 30 days. 30 days, although great in theory, can cause a lot of problems when you're trying to go through punch lists after substantial completion, making sure that everything's complete. So there was a lot of contention on that. Probably the most contentious issue of all of this was the invalidation of pay if paid clauses here in Tennessee. Pay if paid, just to give you all some background for those who may have just a little bit of familiarity with it, as opposed to being, dealing with it day to day. There are two types of contingent payment clauses in Tennessee. One is a pay when paid, and the other is a pay if paid clause. A pay when paid clause is really more of a timing provision. It says I'm going to pay you when I get paid from the owner, assuming that that's going to happen. If it doesn't happen, courts generally default to what is reasonable under the circumstances, and in most cases that I've been involved in, 90 days is about the longest they're going to let that go. So it's not a prohibition. It's not something that goes on forever in terms of how long a remote contractor has to wait. And again, it's generally 90 days. Contrast that with a pay if paid clause, which is a true condition precedent clause that says you're only going to get paid if I get paid by the owner, and you're going to be looking to the owner primarily for payment as opposed to the contractor. The problem with this is that Tennessee actually has a statutory pay if paid clause dealing with retainage. As you remember from a few minutes ago, we said, retainage has to be paid within 90 days. That's to a general contractor. A general contractor only has to pay retainage within 10 days of actually receiving that. So it was, having a provision that's within the Prompt Pay Act that says you can't have pay if paid clauses would create a huge issue when the Prompt Pay Act itself says you absolutely can when we're dealing with retainage. Finally, it was one of the pushes was to create a statutory procedure to have a stop work notice. This is something you see in a lot of form contracts where if a contractor is not paid, they can provide notice similar to a notice of non-payment, and if they're not paid within a certain period of time, they're permitted to stop work on the project until they are paid. Before we get any further, I also want to mention there's a chat bar feature within this webinar. If you have any questions throughout the webinar, feel free to go ahead and type those in. If I see them, I'll try and address them as we're going along. If not, we'll be sure to hit them at the end. So as we were saying, this was a bill that was heavily contested by a majority of the industry. You had the American Subcontractors Association pushing the bill. You had a number of other organizations, architects, engineers, the AGC, the ABC, plumbing, heating, and cooling contractors that were kind of going each way, really just saying, I think there's a better way. We need to try and streamline this. So throughout that legislative session, representatives of general contractors met with the ASA, tried to come to some agreement, never really got anywhere. And so that session ended for 2019, and the bill went to what's called a summer study, or really an informal summer study, where the sponsors called everybody together in a meeting to try and see if there was some sort of agreement that everybody could come to so that the bill could move forward in the next session. This bill was sponsored by Senator Jack Johnson from down in Franklin, who was the Senate Majority Leader, and so he called a meeting in the middle of June, called in all of the interested parties, lenders, the state of Tennessee itself, the subcontractors, the trade organizations for general contractors, the AIA, the architects, the engineers, anybody that could theoretically have some interest in this bill. It was intended to actually discuss a more streamlined version of the bill that was only going to seek the invalidation of pay if paid clauses in Tennessee, as well as the stop work notice procedure. Again, the goal was to get some sort of consensus with all of these organizations, and I threw the LT hard hat in there because there were actually a number of lawyers there as well, from the Tennessee Association of Construction Counsel, as well as the Tennessee Bar Association's construction section. So we had this meeting, and in doing that, we recognized, this is one of the few opportunities where you have everybody in one room to be able to make one decision and see if we can make some substantive changes to the construction statutes here in Tennessee for the better of the entire industry, as opposed to doing what we had done historically, which is one particular group goes to the legislature with a particular issue and tries to do it on a piecemeal basis. Again, there were numerous inconsistencies throughout all of these acts. If nothing else, could we clean it up to make it a little easier so that when we go into, as lawyers, when we go into court on behalf of the construction industry, that we can say this is what the law says, not just this is what the law intended. Make it a little clearer, because it's great. The construction industry is a relationship business. We really don't have that many construction cases in Tennessee that actually go to trial, because the construction industry is great at working things out at the lowest possible level in most instances. And so the idea was, if we can do it on a project, why can't we do it here? So several of us got together and tried to push that idea during this meeting. And the outset was, well, let's try and reframe what we're looking at. We understand subcontractors are saying they personally do not have adequate means to be able to protect themselves from the risk of non-payment. But the general contractors were saying the same thing. If you think back to 2007, 2008, 2009, there were plenty of instances where, owners were defaulting, owners were going bankrupt, which was causing contractors and remote contractors to suffer financially. You saw a real thinning out of the industry, and then throughout the last decade or so, construction has really picked back up. It seems like one of those things where we should not be having payment issues at this time, because there's plenty of construction going on, and there's a number of reasons why this is the case now, but there still are payment disputes, and personally, I'm seeing more payment disputes now than I did historically, and there's a number of reasons for that, but the key was, well, what is the problem? The problem is that the construction industry needs adequate payment protections. We need to make sure that if a contractor is going to do work, or a remote contractor is going to do work, that they're going to get paid for the work that they're doing. We have these current construction laws that are all intertwined, and they provide some protection to the industry, but they're inconsistent, and through practice and trying to enforce them, we've shown that they're insufficient. Not insufficient in intent. It's clear that contractors should be paid for their work, but in terms of being able to obtain a remedy, going into court and trying to show a court and a judge, hey, this is what happened, this is what the law says, this is why I should be paid. There were a lot of roadblocks along the way to that. Anything from a court just not being interested to where you're having to explain to them the law, something that can be relatively confusing for somebody that's not dealing with it on a day-to-day basis. Is there a way we can streamline that? And finally, and most importantly, the risk of non-payment historically was not borne by the party that was best able to manage it. If you think about insurance provisions on a lot of farm contracts, most of them are set up so that a party who is going to obtain the insurance is the one who's best able to manage the risk. It should be the same way in terms of payment. So how do you resolve that problem? We started looking at, well, first and foremost, you've got to have internal consistency. It doesn't matter what change you make, if when you take it to a judge or to a court or to an arbitrator, if they can't understand it, it's not really going to make much of a difference because you're going to be in the same position you've been in, trying to explain the law according to Wally again. Second was eliminating loopholes in the relevant statutes. There were several instances where the law said what it said, but at the same time, there was a little out, or there was this hidden argument you could make to try and get out of being required to perform your obligations, whether that be as an owner, as a lender, or as a contractor. Finally, it was making sure that there were adequate timing, notice, and penalty provisions to protect the industry. There's plenty of avenues and statutes set up to protect owners and protect lenders. Although we have these statutes, they had issues, and so there weren't sufficient protections for the industry itself. So that was June. Fast forward a little bit, we started having, the result of this meeting was that a grouping of subcontractors began meeting with several members of general contractor organizations. And then me and another lawyer here in Nashville named Brian Thomas really initially served as more of mediators than anything else, just trying to help facilitate discussions between the groups to try and see if there was some sort of resolution that we could have. From that, about the second or third meeting, instead of butting heads completely, everybody started getting into more conversations, making it more industry focused as opposed to looking at their specific issues that they were interested in. It was also important, they had a breakthrough moment where they realized that the individuals in the room were not the problem. You had general contractors saying, well, I pay my bills every single time. You don't have these issues with me. We've never had an issue on our projects. You had some contractors saying the same thing. Well, it's not you, it's somebody else. And then on the flip side of that, a general contractor looking over to a sub saying, your work is always great. We never have to worry about you. It's not you, it's this other guy. And so once they got past the, I'm not the problem, let's focus on what the problem actually is, which is we need to make sure that we are going to be protected as an industry and not just as an individual company. Made huge strides over the next few months into October, coming up with a proposal that would be comprehensive for all of these statutes, to be able to bring them up, into 2020, which was going to be a good year before March, by the way. So what are some of these changes? Well, initially, it's better managed risk. It's putting the risk of non-payment where it should be. Instead of it being a risk of non-payment, it's a you need to pay on the part of an owner and a lender. The second is providing additional notices and forms. One of the things that was consistent throughout all of these meetings was that subcontractors particularly did not want to have to spend a bunch of money to do some of the preliminary work to protect themselves. They didn't want to have to hire a lawyer to send a notice of non-payment every month. They didn't want to have to hire a lawyer to draft a notice of lien. Sending a notice of defects or a response to an allegation of defects. They didn't want to have to engage in additional expenses when to the subcontractor, we're already not getting paid. So it was providing some additional forms and notices in that regard. The right to stop work, which was originally rather contentious, ended up being something that everybody agreed on in the way that it was formatted. General contractors repeatedly said, there's many instances where I would love for a remote contractor to go ahead and file a lien, to go ahead and send a notice and threaten to stop work, because that's probably the only thing that's going to get the attention of the owner. It's one thing for me to submit my pay applications as a GC, but I never know if it's just sitting on somebody's desk, if there's really any issues. We really need a means to facilitate communication so that if there are any issues, we actually know about them, as opposed to somebody telling, the architect, assuming that the architect is going to tell the contractor. There were many instances of that. And so one of the changes is the introduction of a right to stop work, both as a GC and a remote contractor. Similar to that, or more of a supplement really, is a demand for reasonable assurances that is now a part of the construction statutes. This is something that is already a part of the AIA forms and other form documents, the consensus documents, being able for a GC before construction to make sure that an owner is actually adequately financed, that they have the money not only to pay for what they think they're going to have to pay under the general contract, but also having contingency amounts. Change orders on most projects run about 10% of what the initial contract amount is. It's making sure that, your retainage, which is now 5% as opposed to 10%, but making sure that your retainage is not going to be used as a weapon to try and pay for owner changes. So making sure that before the project begins that the owner is adequately financed. Similar to that, if a contractor or a sub is not getting paid during the project, in addition to the right to threaten to stop work, the subcontractor and the general contractor at that time can make a renewed demand, or a new demand if they didn't initially, to make sure that the owner is adequately financed. Once that information is provided, owner can't change it. Skipping one real quick in terms of the limitations of liability, there's a number of limitations of liability in many contracts and in many contexts. Anything from, we the GC are not going to be responsible, if it's a cost plus contract, for anything over our fee. We're not going to be responsible for a specific monetary amount, $500,000. You pick it. It's very common in the design context. You see it sometimes with just a general limitation of liability with contractors. But what you see a lot of times is a waiver of consequential damages, which is itself a limitation of liability. And so in Tennessee, limitations of liability, there's a test, a multi-factor test, that courts look at to determine whether or not that provision is going to be enforceable. The first step of that is determining whether or not it violates the public policy of the state of Tennessee. And so it was important to have some sort of statement in there to at least get over that first hurdle, that limitations of liability do not violate the public policy of the state of Tennessee. So that was introduced. So as a flip of that, if somebody actually has a claim, in Tennessee we have a statute of limitations, which is generally 3 years for property damage, 1 year for personal injury. If somebody's hurt on a construction project, or if there's a third party walking down the street, if you have an incident where something's dropped, scaffolding's there, they somehow get injured while they're walking by a site. Personal injury has to be brought within 1 year. If there's any property damage, again, that's 3 years. We also have a statute of repose, which is an absolute bar on claims of 4 years. Generally, any claim that relates to construction has to be brought within 4 years of substantial completion. If it's brought within that third year, or the fourth year, there is an extension of the statute of repose up to 1 year further. So at the maximum, any claim has to be brought within 5 years. There is, the way the statute of repose is written, it says an action has to be brought within 5 years. Under the statutes, an action is defined as really a court proceeding. This is something that really was under the radar. Nobody really paid attention to it until about 1.5 years ago, when there was an arbitration award that granted relief on a claim that was well past the statute of repose. And the arbitrators looked at it and said, we don't think this should apply, but the way the statute is written, it only applies in litigation. And so statute of repose does not apply to arbitration proceedings. That created a huge issue within the construction industry, because you have many instances where contractors are agreeing to arbitration awards, and by doing so, unless you got very specific in terms of when claims had to be brought within the contract itself, you were relying on the Tennessee statutes, which have now been construed as saying statute of repose doesn't apply to arbitration. And with that, all of the planning, risk analysis that's been done on the front end goes out the window, because there's really no limit to your liability at that point. So it was important to consider that in coming up with revisions to these statutes. So what are the changes? Well, with the mechanics lien laws, you're really not going to see a whole lot of change substantively. The changes are primarily to the language itself, making sure that it's internally consistent and that it reflects the changes that were made back in 2007, and that those flow through all of these other statutes. Again, it's primarily related to the definitions and the terminology. There's some minor changes here and there, but nothing that the industry as a whole needs to worry about in terms of day-to-day performance or the enforcement of your rights under the mechanical lien laws. I do think in the future, even though the parties did not agree to extend the deadlines from 90 days to 120 days, I do think that's something to be on the lookout for here in the next few years, because there really wasn't a lot of disagreement to that in terms of the 90 days for notices of non-payment and recording of liens. There was a lot of pushback in terms of extending the right for a remote contractor to be able to enforce a lien for up to 1 year, just because that affects a number of other parties. And realistically, I think it'll probably just be a modification of the notices of non-payment, or potentially the the requirement to record a lien within 120 days as opposed to 90. I think extending the time period for recording a lien is probably the most likely, but it could be a combination of those moving forward, just something to think about. In terms of the Truth in Construction Act, there's a number of changes here, all for the better for the commercial construction industry. Really, there's no change as it applies to residential construction, but again, it updated the definitions to be able to make it much clearer, had minor changes to ensure that record-keeping requirements only applied to residential projects. And in this case, if you have to provide the pre-construction notices, those are only on residential projects. That's what it was intended for originally, and that's the way it should be. There are a number of Tennessee cases already that find that in the commercial context, you're dealing with sophisticated business entities. You're not dealing with mom and pop shops so much. You're not dealing with unsophisticated homeowners who don't understand the process. And so there's no reason that a contractor should be required to provide all these notices for something that an owner particularly already knows about. And in most instances is represented by a lawyer. They're going to know about it. So if you already know all of this information, why should we be providing it? That requirement's been removed. The other is, because that requirement was removed, it was also removing the criminal penalties for contractors in the commercial context. In my experience, it's something that had only been used as a weapon, as a negotiating tactic. I know of a handful of cases where the state has actually prosecuted that or threatened to prosecute it, but it's been instances where it was very clear fraud, which they'd been able to go after anyway. You didn't need to rely on this particular statute. And so if that was the case, why give an owner, the opportunity, even though a lawyer can't threaten criminal penalties as part of the settlement of a civil case? It was something that happened. And so it was important to remove that so that negotiating tactic was gone. The biggest changes, again, came within the Prompt Pay Act. And again, just generally providing additional notices and forms. There's always been a right to seek injunctive relief under the Prompt Pay Act, but there's a number of hurdles you have to jump through. Most particularly, you couldn't reach the banks, which held all the money. The other was that most courts were going to require you to, if you were a remote contractor, to go through the general contractor before you could reach the owner. Here in Tennessee, if we have a situation where an owner is holding retainage, an owner is required to release that within 90 days, and you have a pay if paid clause, as a remote contractor that says you can't get your money until the general contractor does. Me suing the general contractor is not going to do anything because the general contractor doesn't have the money. So we made it clear that remote contractors can seek injunctive relief directly against the owner. They can go ahead and request that a court require that the owner release retainage or pay that into the court's registry. Do something to make sure that it's out of the owner's hands and into the hands of the parties that it's due. Remember, Tennessee is a trust fund state, which means any sums that are dedicated for construction and any sums that are received on account of construction, labor, materials, services are held in trust for the party to whom they're due. So if an owner has those funds, they're holding it in trust for the contractor and the remote contractor. Those are already their funds. They're just being held by somebody else. And so it made no sense to require an action against the general contractor when really what you were trying to get is money that you were owed by somebody else. Another is in an attempt to eliminate some of the caps on the penalties. In Tennessee, with retainage, if retainage is not set up and retained, or excuse me, if the retainage account is not set up with a third party as an interest-bearing escrow account, and money when it is retained is not deposited into that account, there are actual penalties historically that $300 a day that would accrue from the time the money was first withheld until it was either paid or until it was deposited into a compliant account. Even it was clear from the intent of that law that those penalties were supposed to continue to accrue from the first time they were withheld all the way through a project until they were paid. Those can be substantial. $300 a day is about $108,000 a year. And so on some of these longer projects, if you were a site subcontractor or if you were the general contractor, your money had been held for upwards of 2-3 years sometimes. With some of the remote contractors, they're sitting there and they've done all their work. It's lessened here recently with the reduction of retainage to 5%. But you had a substantial amount of money that was sitting out there that you couldn't do anything with. And so if retainage is not at least in an interest-bearing escrow account, even if the interest rate isn't great, you're certainly not getting anything on your money. And so the penalties were a way to try and compensate for that and provide an avenue for relief, give some relief on some of the attorney's fees that the parties would have to incur in trying to enforce those provisions. So one of the changes was changing that term penalties. There was a case here in Nashville that said a penalty cannot by statute accrue longer than 1 year. So even if an owner had your money for 5 years, you were only going to get penalties for 1 year. So that was changed to the term damages, just a slight change, to try and change that so that those penalties, those damages are actually going to continue to accrue throughout the life of the project. Another big change, although it's depending on the project, could be minor, is the change of the interest rate. Historically, 10, 15 years ago, the interest rate on construction projects defaulted at 10%. If there wasn't an interest rate in the contract, it was 10% for pre-judgment and post-judgment interest. That changed a number of years ago to where it was a prime plus interest rate, and right now you're looking at about 5.2%. Some of the discussions between the general contractors and subcontractors, they were very candid and said, look, I can go borrow money for less than what it's going to cost, even if I withheld your money to pay interest on it at this point. It makes no sense for me to go ahead and pay if there's a dispute, because I can just go ahead and get the money, make money off of it, and then pay you off at the end, and I've still made money. So the other side of that is the state of Tennessee. There's actually two Prompt Pay Acts here in Tennessee. One is the Prompt Pay Act of 1991, which applies generally to construction. The other is the Prompt Pay Act of 1985, which applies to general purchases by the state of Tennessee. Under the Prompt Pay Act of 1985, if the state buys ballpoint pens, paper, desks, you name it, they're paying 18% interest. And so the idea came up, well, if the state of Tennessee is going to pay 18% interest on ballpoint pens, the state of Tennessee should pay 18% interest on some of these buildings they're building if they're not going to pay in accordance with the contract. Similar to that, if the state of Tennessee is going to pay it, everybody should pay it. And so it's increasing the interest rate to 18% on all amounts that are due. So if the GC is not paid by an owner, those amounts are going to continue to accrue interest over the life of the project. We talked a little bit earlier about the demand for adequate assurances and stop work, and we'll talk a little bit more about those here in a few minutes. But the result of all of this was better managed risk throughout the industry, pushing it back upstream as opposed to pushing it downstream on the parties who are not able to manage it and are really living on more of a shoestring budget as opposed to some of these owners. So we run a little short, and I want to make sure we have time for questions. Again, removing the cap on damages was just a matter of changing the term penalties to damages. One of the important aspects of this is clarifying the right to injunctive relief, which says that if you seek relief from an owner or from a remote contractor or a general contractor, whoever you have a contract with, if they are not paying retainage specifically in this one section, you can seek equitable relief, including the right to require a lender to pay funds into the court's registry. Before we get into that, let's skip forward a little bit. So historically, this was the blanket exemption for the lending industry. It said the Prompt Pay Act doesn't apply, period. That was something that had to go. And I think if we had had more time, we could have been successful in getting rid of that outright. As part of the legislative process, I'm sure most of you have heard, seeing legislation get made is a lot like seeing sausage get made. It's an interesting process, I'll say, but it's wild and constantly changing throughout the entire process. I think we had a plan in place at the beginning of the session that we were going to be successful at trying to get this taken out completely. You had in March, COVID hit, which was going to, obviously created issues because the legislature went into recess and came back at the beginning of June. They were looking at only doing budget bills, and the industry representatives who had been working on this bill said, you know what, we got to find something that we can come up with here. We've made so much progress ourselves to allow, this one issue to derail the whole thing. How can we get this in front of the legislature? And how that was done was coming up with what I'm calling the COVID compromise. Throughout the process, the Tennessee Bankers Association had thrown up a number of amendments to this bill to try and derail it because they did not like the idea that the banking industry would somehow be brought into a construction dispute, consistently saying we're not a part of the construction process, which I laughed at and said, well, that's interesting because you pay all of the money. You're holding the money during construction. You require contractors to execute subordination agreements all the time. A lot of assignments, they are essentially having to bend over backwards for the banking industry, and the banking industry is fully protected. If the owner defaults, the bank, the lender, the savings and loan credit union, whoever, takes over the project. They have a project at the end will be completed, yet, they have foreclosed on the project. They've eliminated all of the lien rights so that they're secured, but nobody else is secured. They also, have no obligation to make payment. So you have the construction industry, which is really financing all of these projects by putting out the labor, materials, and services on the front end, with the expectation that they're going to get paid, but in the event of an owner default, getting nothing or very little. And so there had to be some sort of compromise to get the banks on board, which is what we're calling the COVID compromise. So under the new exemption, that's not really an exemption. It makes the banks feel better that they get to keep the language of subsection A, which is the general exemption. However, there are two big caveats to this. One is that if a bank performs or undertakes its own project, whether it be a branch, a data center, whatever, Prompt Pay Act applies. The Prompt Pay Act will also apply in the event of an owner default. If an owner defaults and the bank takes over the project, banks are back on the hook. So that, in reality, the Prompt Pay Act is not going to apply to a bank in their traditional role as a lender because they're not going to have any liability in that instance. But when they take over their own project, if they're holding funds that belong to contractors, or if they're doing their own project, they take over a project, or if they're holding funds that belong to a subcontractor or a general contractor, they're going to be on the hook for those. So going back to the injunctive section, there is a big statement within the Prompt Pay Act now that even though the Prompt Pay Act does not apply to banks generally, a bank is required to comply with an order of a court that requires them to make payment under an injunction, a mandatory injunction. So if I'm not getting progress payments as a contractor, if I'm not getting retainage released, I can go to a court, and even though I'm not seeking bank relief against the bank per se, I can get an order that says the bank has to pay all of the money that it is holding into the firm or into the court's registry. This allows you to, where historically you would be able to say, well, I need to seek relief against the contractor or the owner. They would go into court and say, well, I don't even have the money. We have to get that from a bank. The court then looks at it and says, well, the Prompt Pay Act doesn't apply to the bank, so you're out of luck. This happened over and over the past few years here in Nashville. So it's a huge win for the industry to be able to go seek relief from the banks who are going to be holding the money, as opposed to being told, well, the owner had a default, or the owner won't do this, or we need more information. There's no questions now that you can get relief directly from the lender. The next is that the bankruptcy of a party does not serve as a defense to non-payment. So if you're in an instance where you have an owner default or a contractor default, they are insolvent, you can't get any money out of them. You don't have to worry about a bankruptcy trustee coming and trying to get money, which on an aside they can't do already, but makes it clear. You also don't have a lender saying, well, we're not going to pay money to a bankrupt owner, with the hope that they're in the expectation that they're going to make payment to you. Now it doesn't matter. Those defenses go out the window, and you can seek relief directly against the lender again. Interest rate, again, just remember that goes up to 18%. In terms of notices are going to be the same. There are a couple of new forms that contractors can use for a notice of non-payment that you see in the mechanics lien statute. There's a similar notice now for Prompt Pay Act notice within the Act itself. It's very similar. It just says, if you don't pay, I haven't been paid. If you don't pay me within 10 days, I'm going to be moving for injunctive relief. In addition to that, all of the notices with the stop work and the reasonable assurance demand are all tied to that initial notice to seek relief under the Prompt Pay Act. So as a general contractor or a remote contractor, if you're not paid, you can send that initial notice. If you're not paid within 10 days, you can include as that notice a notice to the owner that you're going to be stopping work. And there is some risk to that. You need to make sure that there's not any other default that an owner can allege on the part of a GC or a subcontractor. But as long as payment is the only issue, you'd be able to stop work within 10 days. Once an owner does make payment, there is a provision that requires the owner or the GC to grant an equitable extension of the contract schedule. So if you're under a contract that says time is of the essence and you're required to perform within a given period of time, if you send a notice to stop work and a notice that you haven't been paid and you aren't paid within 10 days, you can stop work. Say you're paid 10 days later, all of a sudden the owner is required to extend the contract schedule an additional 10 days or whatever period of time the owner or time that went from the date of the letter to the date they actually make payment. Similar to that on the demand for reasonable assurances, when you file those, you can include a section of this notice that we have that says, in addition to, if you're not going to provide me notice, or if you're not going to make payment or provide me notice of adequate legal reasons, meaning they think there's a default under the subcontract, you do have to provide me notice of what your financial arrangements are to make sure that you're going to be able to pay all sums that are due from this point forward. And again, there's a form for both the stop work notice and the reasonable assurances within the Prompt Pay Act now. In terms of limitations of liability, again, we hit that earlier, but it's just a general statement that in terms of the public policy of the state of Tennessee, limitations of liability are perfectly acceptable. You still have to meet the other factors, which are that they bear a reasonable relationship to the risk that's undertaken. One instance where you can't have a limitation of liability is with home inspection. A lot of times you'll see those contracts where it says, we're limited to $100 or whatever our fee is, whichever is more. Meanwhile, there could be thousands, tens of thousands of dollars in damages that would be there. The courts have said it's against the public policy to limit your liability to that extent. We're not really worried so much about that. In most instances in the construction industry, if you have a limitation of liability that bears a reasonable relationship either to your fee or to a monetary amount that's reasonable in light of the project, those are going to be acceptable. But this at least gets you past that first hurdle. Again, with the statute of repose, there's uniform applicability now. We made some minor changes throughout this statute to make it clear, but the principal change is that the statute of repose now is very clear that it applies in litigation and in arbitration. So, I appreciate the opportunity to speak with you today. I'm happy to take questions now. And just so you know, Leslie, I just got an email that my 10 o'clock conference just got moved. So we've got a little more time than I thought.
Okay, whoosh, because we do have some questions for you, Wally, and thank you so much for the review. I think that was very helpful in understanding the context of going through the process with legislators and understanding that this was a compromise, and it was to kind of steer in a better course than what was being presented last year for both the subs and the GCs and the whole construction industry. So we really do appreciate your work, and it's been the amount of work that you put into this is really incredible. So thank you very much.
Absolutely.
The major question that we keep getting asked over and over is about pay to paid, and so there was previously a common law, pay if paid, to protect general contractors who didn't get paid. So this statute takes away the GC's protection when the owner doesn't pay, but doesn't add anything because you always had the right to stop work. So can you address that a little bit? I mean,
Sure. I think I know where they're coming from. So in terms of pay if paid, just to be clear, nothing in this legislation says pay if paid is invalid. You can still have a pay if paid clause in Tennessee, a true pay if paid clause, meaning if you as a GC don't get paid, you don't have to pay your subcontractors. Now, the big caveat, and I rushed through it, and I probably should have spent more time on it, in response to any notice under the Prompt Pay Act that a contractor is going to seek relief, whether it be a GC or a remote contractor. In this instance, we'll focus on the subcontractors. If a subcontractor sends a notice saying, hey, I haven't been paid, and they throw in hey, I'm also going to stop work if I don't get paid in 10 days. You got to remember, under the Prompt Pay Act, you're not required to just make payment. If there is a legitimate dispute, that is a totally valid reason not to make payment, whether it be there's a construction defect or if you're a GC, whether you haven't been paid by an owner. The Prompt Pay Act requires that you provide some sort of response, whether as an owner or a GC, of what adequate legal reasons you have for not making payment. Again, if there's a default under the subcontract, whether it be defective work, whether it be insufficient labor, I mean, you name it, that is a sufficient and an adequate legal reason for non-payment. And so, and even the pay if paid, if you haven't been paid, that is an adequate legal reason why you haven't made payment. As long as the pay if paid provision is in the subcontract, you can absolutely 100% rely on the pay if paid clause as the reason for non-payment. And in those instances, a subcontractor would not be able to stop work. That's why we tried to make that very clear to the remote contractors during these negotiations, that if this is something you really want, you have to still understand that the risk is totally on the remote contractor to make a determination of whether there is a default under the subcontract. Because if there is, and they stop work, the stoppage of work is the first material breach.
Okay. Let's see. I had another question on retainage payment. If retainage payment is due within substantial completion, is substantial completion for the entire project or for the scope of work?
That's something that's still left up in the air. So what you can do, and the law itself does not really address that. What my recommendation to people has been is if you have a large project, whether it's a skyscraper or a large industrial project, if it's possible to break it down into phases, which happens a lot, have separate substantial completion dates for each portion of the project. But you need to make it clear that retainage would be paid on those portions. Very candidly, there are a lot of large owners here in Tennessee that have totally gone away from retainage just because of that 90-day requirement, and they're going strictly to a project performance schedule. So, 20% you get paid here, 50% you get paid here, 75%, and then they have something else. The other aspect to remember is retainage is retainage. It really is just a project completion guarantee. but the Prompt Pay Act allows an owner or a GC to withhold other sums, and I'm going to use big quotation marks, other sums for other reasons. So I could have a 5% retainage, but I could also have a 10% that is going to be withheld until remote contractors or GCs give me, all project closeout documents, warranties, lien waivers. I mean, you name it. You can make up pretty much anything, and there's been a court case over the last year and a half, 2 years, that is affirmed that and said you can withhold money for other things. So it's important to note, if you have retainage, that's just retainage, the standard retainage. And, a lot of it you all have some great construction lawyers down in Chattanooga, I know, that can draft really good contracts to make sure that, if you want to do that and have partial retainage be released throughout the project, depending on those separate substantial completion dates, you can absolutely do that. But it's not something that's addressed by statute. And in my experience, most courts are reluctant, even if you have an instance with a large project like that, to go on a piecemeal basis and say, okay, substantial completion for the site work was done, January 1st, even though substantial completion for the project wasn't done for a year and a half after that. They're going to be very reluctant to require an early release of retainage. Although, again, with good contracting and good relationships, a lot of times you can get that taken care
of. Okay, and thank you. Back to the pay if paid.
Sure.
So that was actually removed from the law. I mean, it's out of the statute now, right? It used to be in there, and now it's out. And I think that's where it's maybe causing some confusion. Is that correct? But you're saying that even though it's not specifically in a statute, that you still have those rights to you. Can you delve into that?
Sure. A little bit of background on it. So Tennessee case law does not expressly state, at least in the Court of Appeals or the Supreme Court, that you can have a pay if paid clause. There is a case that has kind of beaten around the bush and said that it would be acceptable, but that case was dealing with a pay when paid clause. And so there's nothing on record that says, pay if paid is valid, pay when paid is valid, or that says the opposite. Well, I take that back. Pay when paid is 100% valid. There's nothing, at least with pay if paid, that says it's valid or invalid. There are plenty of trial court decisions and arbitration awards across the state of Tennessee that enforce pay if paid clauses. So from a common law standpoint, if we're going before an arbitrator or a court and we have a pay if paid clause, you can pretty much guarantee it's going to be enforced. The issue with the statute is the statute has always had a pay if paid clause in terms of retainage. A general contractor is not required to release retainage that is being withheld by an owner until they actually receive it. That is still the law today. What changed was in the initial bill that was proposed by the subcontractors, they wanted to invalidate pay if paid clauses completely. And what we did was come up with a completely new bill, which is what all these changes were under. And the old bill that was pushed by the American Subcontractors Association at the close of session, it just died. And so no action was taken on it. And I believe Senator Johnson actually withdrew that bill from consideration.
Yeah.
So in terms of the statute, pay if paid and pay when paid, or we'll just say generally, pay if paid and pay when paid were always valid and currently are valid moving forward.
Okay. Speak now or forever hold your peace. Does anybody else have any questions that you want to text me real quick or email me or put in the chat?
And while they're doing that, if I can have a shameless plug here, with Lewis Thomason, we normally have an annual construction law seminar at each of our offices in Knoxville, Nashville, and Memphis. Because of COVID, it's normally held toward the end of the year. Because of COVID, we have gone virtual. And so if you're interested, you can email Tanya Freeman in our office. It's tfreeman@lewisthomason.com. These are all free seminars. Excuse me. They're all free seminars. The idea has been reconstructed is the overall theme. We did a presentation similar to this one last week. And then upcoming in August is essentially on drones, unmanned aircraft systems, how you can use them in construction, trying to get paid, in a COVID environment in September, employment law considerations in October, and then some unlicensed contracting issues that can come up, whether you yourself are unlicensed or if you're dealing with some unlicensed contractors down the stream. So if you're interested in any of those, again, they're free. Just contact Tanya Freeman in our office, and she'll be glad to help you out and get you set up for those.
Okay, thank you. Okay, I don't see any other questions at this point, but we may email you if some people have thoughts that come up, if you don't mind if we do that. And
I don't mind at all.
okay, well, thank you again, Wally. Thanks to everybody that's on the call today. If you do have some follow-up questions, don't hesitate to send those to me and we'll get those over to Wally. Thanks, everybody. Have a great day.
Thank you all very much.
Bye-bye.
Bye-bye.